3 weeks after her father's funeral, Elena found a wire transfer for $340,000 sent from the estate account to a limited liability company she had never heard of. The company was registered to her father's attorney, the attorney who had just handed her the will, the attorney who had represented the family for 20 years. She sat at her kitchen table with the bank statement in her hand, and she told herself there had to be an explanation. A loan. A fee arrangement. Something Marcus had agreed to and simply never mentioned. She was still telling herself that when she found the second wire transfer, and the third. Stay with me. Because what Elena uncovered over the next 3 months made those wire transfers look like a rounding error. Marcus Hale spent 41 years building something most people never get to leave behind. He started with a single rental property, a duplex on the north side of the city that he bought the year Elena was born. He worked a full-time job in logistics management and managed the property on weekends, fixing pipes himself when he couldn't afford a plumber, painting walls himself when the tenant moved out. He was not a wealthy man by any standard that would impress anyone who hadn't watched him do it. But he was patient, and he was consistent. And over 4 decades, he turned one duplex into a portfolio of 7 properties, a paid-off family home, and investment accounts that had grown quietly while he worked, while he raised his children, while he drove his wife to her chemotherapy appointments and held her hand when the treatment stopped working. By the time Marcus turned 73, everything he had built was worth $2.8 million. He had 2 children. Elena was the eldest. She was 44 years old, a project manager for a mid-sized construction firm, and she had never once questioned what her relationship with her father looked like from the outside. She called him every Sunday. She drove him to his cardiologist appointments when his legs started giving him trouble. She sat with him on his back porch in the evenings and listened to him talk about things he had already told her before: the duplex he bought, the tenant who once paid rent in cash inside a paper grocery bag, the summer he and her mother drove cross-country before Elena was born. She listened every time. She never once let on that she had heard the stories before. Derek was the youngest. He was 41, and he had walked out of a family dinner 7 years earlier after a dispute that nobody in the family could fully explain. It had begun as an argument about money, about a loan Marcus had given Derek that Derek felt should have been forgiven rather than repaid, and that Marcus felt should have been acknowledged. It had escalated in the way that arguments between fathers and youngest sons sometimes escalate, past the original point and into older territory, into accumulated resentments that neither side had the language to address cleanly. By the time Derek left that evening, he and Marcus had said things that could not be unsaid. Derek did not come back for Christmas that year. He did not come back the year after. Marcus never stopped loving Derek. Elena knew that. He kept a photo of the 3 of them on his nightstand, taken at a lake house the summer Derek turned 16, all 3 of them squinting into the sun. He talked about Derek carefully, the way people talk about a wound that hasn't closed. He still hoped for reconciliation. He told Elena this on more than one occasion, usually on the back porch, usually after the second glass of wine. That hope, Elena would come to understand, was the most valuable thing Howard Greer ever found. Howard Greer had been the Hale family's attorney for as long as Elena could remember. He had drafted Marcus's first will when Elena was in middle school. He had handled the purchase of every rental property. He had been present at the closing on the family home 30 years ago. He was at the hospital the night Marcus's wife, the woman Elena called Mom and Marcus called his whole world, passed from ovarian cancer 12 years ago. He was steady and familiar in the way that very few people manage to be, and Marcus trusted him in the uncomplicated way that people trust someone who has been present for the most important moments of their lives. Howard was 62 years old, trim and professional, the kind of man who wore a suit to client meetings and remembered the names of clients' children. He had a daughter himself, and he had mentioned her to Marcus enough times that Marcus felt he knew her. He had a competent and well-regarded practice. He had no disciplinary record that anyone would have thought to look for. He was, by every visible measure, exactly what he appeared to be. Marcus passed on a Tuesday in October. Cardiac arrest at home, in the early morning. Elena got the call from a neighbor who had gone to check on him after he missed their weekly coffee. She drove to the house in a state that she would later describe as very still. Not numb, still. As if her body had decided that stillness was the only appropriate response to something this large. Howard called her within 48 hours. He was professional and measured and appropriately somber. He arranged the reading of the will for the following week at his office downtown. He told Elena the estate was complex but manageable, and that she had been named executor, and that he would guide her through every step. Elena arrived at the office on time. She was shown to a conference room with dark wood walls and a long table. She poured herself a glass of water and sat down. Derek was already seated when she walked in. She had not seen her brother in 7 years. He looked older in the way that people who have been through something difficult look older. Not aged exactly, but worn. He did not make eye contact when she took her seat across from him. He had his hands folded on the table and he was looking at the surface between them. Howard arrived 2 minutes later, thanked them both for coming, expressed his condolences, and began to read. The will left the family home and the primary investment accounts to Elena. She exhaled slowly at that. The rental properties, worth approximately $900,000 combined, were to be liquidated and split equally between both children. That also seemed consistent with what Marcus had told her over the years. And then Howard reached the final clause, a discretionary estate management arrangement signed by Marcus 8 months before his death, granted Howard Greer's firm a 15% administrative fee on all estate assets passing through probate, plus a separate 12% commission on the liquidation of the rental portfolio. Elena looked up from the document. She did the arithmetic in her head. It took her less than 30 seconds. 15% of $2.8 million was $420,000. 12% of $900,000 was $108,000. Combined, Howard Greer's firm stood to collect more than $500,000 from her father's estate. She looked at Howard. He was watching her with the patient, practiced expression of a man who had delivered this information before and had rehearsed the moments that followed. "This is a standard arrangement for estates of this complexity," he said. "Your father reviewed it carefully. He had questions, which I answered. He signed with full understanding." Elena nodded once. She did not say what she was thinking. She was thinking that her father had spent 41 years making decisions with extraordinary care, that he had repainted his own rental properties to avoid paying a contractor, that he had driven a 12-year-old car for 8 years because the payments on a new one didn't make financial sense. She was thinking that a man who operated that way did not casually sign a document authorizing $500,000 in fees to his attorney. She took a copy of the document when the meeting ended. She drove home. She sat at her kitchen table and read it 3 more times. Then she called a friend who was a CPA and asked a single question. Is a combined fee of 27% of an estate's value normal? Her friend laughed. She thought Elena was joking. She was not. Elena had been named executor, which gave her access to the estate's full financial records. She began requesting them the week after the will reading. Bank statements, account histories, property records, tax filings going back 5 years. The first thing she noticed was the lien. One of the rental properties, the North Duplex, the one Marcus had bought the year Elena was born, the one he had always called the beginning of everything, had a lien filed against it 14 months ago. Elena had no memory of her father ever mentioning a lien on that property. She had reviewed the property records with him as recently as 18 months ago when he had considered refinancing, and there had been no lien at that time. She pulled the lien documentation. It had been filed by a company called Greer Asset Holdings, LLC. She searched the LLC registration on the state business portal. The sole registered member was Howard Greer. Elena sat very still for a long time. She told herself again that there could be an explanation, that Marcus might have taken a loan she wasn't aware of, that there might be a perfectly legitimate reason why his attorney had a personal financial interest in one of his properties. She told herself this in the deliberate way that people tell themselves things when part of them already knows the answer. Then she called Howard's office and left a message asking about the lien. Howard called back 4 days later. He told her it was a bridge loan, that Marcus had needed liquidity 18 months ago for a property tax matter, that Howard had personally provided the funds as a convenience to a long-standing client, and that the lien would be discharged as part of probate. Elena asked to see the original loan documentation. Howard told her his assistant would pull the file. 3 weeks passed. She followed up twice by phone and once in writing. Each time she was told the file was being located. The file never arrived. Elena stopped waiting and contacted the State Bar Association instead. She asked a procedural question. Was an attorney required to produce documentation of a financial transaction with a client upon the executor's written request? The answer was yes. Within 30 days of a formal written request, she sent Howard a certified letter that same week citing the relevant statute. 2 days later, a paralegal emailed her a typed one-page summary on Greer and Associates letterhead. No original loan agreement, no signed authorization, no transaction records, a summary document with no notarization and no attachments. That was the moment Elena stopped giving Howard Greer the benefit of the doubt. She made 3 phone calls that afternoon. The first was to her own bank to understand exactly what documentation a legitimate private loan required. The second was to a colleague who had gone through a contested estate with her own family. The third was to a probate attorney named Patricia Chen, who had spent 20 years specializing in exactly the kind of situation Elena was beginning to understand she was in. Patricia Chen reviewed the documents Elena provided over 3 days. When she called, her voice had the careful, measured quality that Elena had come to associate with lawyers who are about to say something that changes the shape of a case. "The fee arrangement alone may be challengeable," Patricia said, "but I want you to request something before we go further. I want you to request Howard's complete billing records for your father's estate. Every time entry, every invoice, every meeting notation, going back 5 years. As executor, you are entitled to them, and I want to see them before we decide what to do next." Elena submitted the formal request. She sent it certified mail with return receipt. The billing records arrived 10 days later. Patricia spent 2 days reviewing them. Then she called Elena. "Howard billed your father for 47 separate meetings over the past 2 years," Patricia said. "Strategy sessions, estate reviews, document signings, consultations." Elena waited. 47 meetings in 2 years sounded like a lot, but Howard had been managing complex estate documents. It was possible. 31 of those 47 meetings, Patricia continued, include Derek as an attendee. The line went quiet. "Your brother," Patricia said carefully. "The son who hasn't spoken to the family in 7 years. According to Howard's own billing records, the records he was required by law to provide, Derek Hale attended 31 private meetings with your father's estate attorney over the past 24 months. Elena found she had nothing to say. "None of these meetings were disclosed to you," Patricia said. "None of them appear in any document Howard provided at the will reading. And your father, based on everything you've told me, never mentioned them." Elena pulled up her phone records from the past 2 years. She cross-referenced them against the dates of Derek's 31 meetings with Howard. She was looking for any call from Derek, any text, any voicemail, any evidence that her brother had been in contact with the family during the same period he had been meeting privately with their father's attorney. There was nothing, not one call, not one message. In 24 months of private meetings with Howard Greer, Derek Hale had not once reached out to the family he had cut off 7 years earlier. She went further. She pulled the dates of the meetings and compared them against her own records. Her notes from Sunday calls with her father, the calendar entries she kept, the emails Marcus had occasionally sent when he wanted to remember something for later. 22 of the 31 meetings had taken place during what Marcus's family privately called his foggy weeks, the periods when he repeated himself, when he lost the thread of a conversation mid-sentence, when he called Elena by her mother's name. She called Marcus's neurologist the next morning. Dr. Raymond Torres had been Marcus's neurologist for 4 years. He was careful on the phone, the careful of a physician who understands that medical records in estate cases become court evidence. But when Elena explained who she was, what she had found, and what she was asking, he agreed to a conversation. Marcus had been formally diagnosed with mild cognitive impairment 14 months before his death. The diagnosis was documented: declining short-term memory, increased suggestibility, reduced capacity to evaluate complex financial information. These were the clinical terms. What they meant in practice, Dr. Torres explained, was that Marcus in the final 14 months of his life was not the same Marcus who had made careful, methodical financial decisions for 4 decades. Dr. Torres had made a formal recommendation in his clinical notes. He had advised that Marcus should not sign any major financial documents without a trusted family member present and without the opportunity for independent legal review. Elena asked when this recommendation had been entered into the record. Dr. Torres told her the date. The estate management agreement, the document that authorized Howard Greer's firm to collect a combined fee exceeding $500,000 from the estate, had been signed 11 days after that recommendation was entered. Elena did not speak for a long time. She was sitting at her kitchen table with the billing records and the lien documentation and the medical records spread in front of her, and she was understanding, for the first time, the complete architecture of what had been done to her father. Howard had watched Marcus decline. He had tracked it, or perhaps facilitated it being tracked, because he had been present enough over those years to observe it directly. He had cultivated Derek, the estranged son, the one Marcus still loved, the one who would have both the motive and the emotional leverage to cooperate, and over 24 months of undisclosed private meetings, the two of them had built something together. They had built a version of Marcus's estate plan that bore Marcus's signature but did not reflect Marcus's judgment. They had built it during the months when Marcus was most vulnerable, most suggestible, most likely to sign what a trusted person placed in front of him without fully processing what it said. The document was technically legal, the signature was real, the notarization was real, but a signature obtained from a man who had been advised by his own physician not to sign complex financial documents, without his family present, without independent counsel in a private meeting with the attorney who stood to benefit most, was not informed consent. It was extraction, dressed in paperwork. Patricia Chen had a name for what Elena had found. She called it undue influence, compounded by breach of fiduciary duty, compounded by potential elder financial abuse. She told Elena that what they had assembled was not just enough to contest the fee arrangement. It was enough to file a formal complaint with the State Bar Association and potentially trigger a criminal referral. Elena filed the bar complaint 4 weeks after her conversation with Dr. Torres. The complaint cited 5 specific items: the undisclosed meetings between Howard and Derek, the absence of proper loan documentation for the lien on the North Duplex, the wire transfers from the estate account to Greer Asset Holdings, LLC, the timing of the estate management agreement relative to the cognitive impairment diagnosis, and the failure to disclose the attorney's personal financial interest in estate property prior to the will reading. Howard's attorney responded within 10 days. The letter was 8 pages, confident and precise, designed to make the complaint appear to be a grieving daughter's misunderstanding of standard estate practice. Elena filed it in a folder she labeled, "Their Response." Patricia had already moved on 3 separate fronts. She had subpoenaed Howard's personal banking records to trace the wire transfers. She had contacted the notary who had witnessed the estate management agreement signing and requested an interview. And she had sent a formal request for records to Derek's last known address. Derek did not respond. The notary did. Her name was Catherine Morse. She had been a licensed notary for 18 years. She told Patricia that she had been asked to attend the signing at Howard's office, that it had been presented to her as a routine estate document execution, and that she had arrived to find a man who seemed confused about what he was signing. Marcus had asked twice, in the span of the same short meeting, what the document was. Howard had answered both times before Marcus finished the question. Catherine had looked at Marcus while Howard spoke, and she had seen something in his expression that she had not been able to name at the time, but that she recognized now, having read about cognitive impairment since the meeting stayed in her memory. She had signed the notarization because she was not certain enough of what she was seeing to refuse. She had told herself after that attorneys know what is legal, that she was there to verify signatures and not to evaluate competence, that it was not her place. She had not forgotten that day, not once. When Patricia called, Catherine Morse said 4 words that would become the foundation of everything that followed. "I've been waiting," she said. "I kept thinking someone would ask." Patricia told Elena after that call that Catherine Morse was the kind of witness who wins cases, not because of what she said, but because of how she said it. Because 18 months later, she remembered the details the way people remember details that troubled them, and because she had no relationship with any party and nothing to gain. The investigation into what Howard Greer and Derek Hale had built, and how it finally came apart in a way neither of them anticipated, continues in Part 2. What Elena found when Patricia's team pulled Howard's personal banking records will change everything you think you understand about this case. Subscribe. You will not want to miss Part 2. Before we close Part 1, I want to step outside the timeline for a moment and talk about what this story is actually about at its core. Because it is not simply about money. Howard Greer did not exploit a stranger. He exploited a man who trusted him because he had earned that trust over 20 years of real presence in the most difficult moments of that man's life. That trust was not an accident, and it was not incidental. It was a resource, cultivated specifically so that it could be spent at the moment it was most valuable, which turned out to be the moment Marcus was least capable of protecting himself. This is what makes this category of betrayal so uniquely devastating. It does not look like a crime. It looks like estate planning. The meetings are real. The documents are real. The attorney is credentialed and professional and has a long track record that anyone can verify. The signature belongs to the person whose estate it is. What isn't visible from the outside is the process by which that signature was obtained, the months of private meetings, the deliberate exclusion of family members who might have asked inconvenient questions, the careful timing, documents signed during the periods of greatest cognitive vulnerability, not during the lucid weeks when Marcus might have pushed back. This is the architecture of undue influence, and the reason it succeeds so often is that it is designed to look like the opposite of what it is. If you have an aging parent, one conversation can change the trajectory of everything. Ask them who has access to their accounts. Ask them whether their attorney or financial advisor has ever met privately with any member of the family without disclosing that meeting. Ask them when they last had an independent review of their estate documents by someone with no financial interest in the outcome. You do not have to be suspicious of everyone to have this conversation. You have to be present. You have to be the person in the room, not occasionally, but consistently, in the way that Elena was, so that you know what is normal and you notice when something shifts. Because the people who do this are almost never strangers. They are almost always someone the family trusted, someone who knew where the love was, and someone who was patient enough to wait until the moment when that love was most exposed. We will see you in Part 2.